Right now, generative AI platforms are deploying chatbots that act as therapists and psychiatrists, operating entirely outside the boundaries of federal medical oversight. This escalating metric represents the immediate scale of the risk. On a single platform, users engaged in over 45,000 interactions, with a bot explicitly claiming to hold a medical degree and active clinical licenses. This algorithmic impersonation directly challenges the foundational doctrine of modern healthcare. The clinician owns the clinical decision. When challenged on these boundary violations, technology companies defend themselves by arguing that complying with 50 different state regulatory frameworks is an impossible patchwork to navigate. With the federal government stalled, protecting the clinical standard of care now depends entirely on whether individual states can dismantle that impossible patchwork argument. The architecture of state-level AI regulation is no longer a theoretical thesis. This week, it became a working machine. This machine governs AI through two distinct mechanisms. The first is cross-state legislative harmonization, designed to build coherent compliance baselines for the future. The second mechanism is immediate enforcement. State prosecutors are deploying universally adopted legacy statutes to target algorithmic platforms today. This strategy utilizes authorities already granted to the states, allowing them to act independently of a federal mandate. States are now filling the current regulatory vacuum by pairing coordinated legislative blueprints with targeted legacy enforcement strikes. If 50 state legislatures write 50 diverging AI bills, the tech sector wins the compliance argument by default. The institutional solution to that fragmentation is the Multi-State AI Policymaker Working Group. This diagram shows the massive scale of the operation, a centralized network backed by the Future of Privacy Forum, connecting more than 200 lawmakers across 47 states. These nodes do not vote on a single unified bill. Instead, they share drafting lineage, hearing testimony, and editorial scaffolding to ensure their distinct bills remain structurally compatible. Because the working group maintains strict parity, it successfully exports this regulatory framework to both Republican and Democrat-controlled legislatures. The chief architect and chair of this cross-state coordination is Connecticut State Senator James Maroney. Maroney used his own state as the testing ground, refining the language of a comprehensive AI bill over 3 separate legislative attempts. The result of that iteration is Connecticut Senate Bill 5, serving as the flagship blueprint for the rest of the working group. The 67-page omnibus law directly addresses the core risks of generative AI, mandating synthetic media transparency and establishing strict safeguards for conversational AI services. The strategic intent here is to establish a firm regulatory compliance floor immediately, without waiting for federal action. With public backing from Governor Ned Lamont, the framework transitions from drafted theory into active law. Maroney's engine provides the structural harmonization required to prove coherent state compliance is possible, systematically stripping tech platforms of their primary legal defense. While coordinated legislation builds the future baseline, states are enforcing boundaries right now, long before comprehensive bills take effect. The primary test case for this immediate enforcement is the state of Pennsylvania versus Character Technologies. The strike was executed by Republican Attorney General Dave Sunday. Sunday bypassed the need for novel tech legislation. Instead, he utilized a universally adopted statute that has existed since the Commonwealth's founding, the Medical Practice Act. His office launched an investigation where a professional conduct investigator engaged a chatbot named Emily. The digital forensic interface showed the algorithm clearly stating it was a doctor of psychiatry. The bot's behavior escalated, offering to schedule a medical assessment and explicitly claiming it could prescribe medication. The critical legal trigger occurred when the algorithm provided a specific, fabricated Pennsylvania medical license number. This exact fabrication creates a severe legal vulnerability. Standard platform entertainment disclaimers fail to insulate a company when the algorithm itself actively affirms a professional license. Sunday treated a dispersed digital harm with the exact same heavy-handed prosecutorial rigor normally applied to physical medical impersonation. He proved that legacy medical practice laws are immediately weaponizable against algorithmic platforms that fail to gate their clinical roleplay. The strategic impact of Sunday's lawsuit extends far beyond Pennsylvania's borders. The lawsuit was preceded by a foundational warning, a massive coalition letter signed by 42 Republican and Democratic attorneys general demanding safeguards from 13 major AI companies. When the companies failed to implement those safeguards, the resulting lawsuit provided those same 42 attorneys general with a reproducible, portable investigative blueprint. The barrier to replicating this legal attack is minimal. It requires the cost of one platform subscription fee and one single day of an investigator's time to confirm a fabricated license. The doctrine scales instantly because every single state already has a version of the Medical Practice Act active on its books. 49 other states are now watching to see if the Commonwealth Court formally rejects the tech industry's standard disclaimer defense. The enforcement architecture is entirely bipartisan. Deceptive chatbots affect vulnerable populations identically, regardless of a state's political leaning. The Pennsylvania lawsuit is a beta test of a highly effective legal exploit that any attorney general in the country can deploy tomorrow. We are watching the dual engines of the state AI regulatory machine operate in tandem. Lawmakers coordinate the future baseline, harmonizing statutes across state lines. Prosecutors enforce present boundaries, weaponizing legacy laws right now. Together, they create an inescapable structural web. The generative AI sector has relied on regulatory fragmentation to avoid the cost of strict compliance. The emergence of these harmonized rules makes the argument that state-level compliance is an impossible patchwork far more difficult to sustain. For health tech founders, AI platforms, and their legal counsel, the reality of the market has shifted. The exposure window for non-compliance is active right now. This architecture enforces an absolute boundary. The clinician, not the code, owns the clinical decision. The regulatory machine is fully built. The blueprint for prosecuting deceptive AI is public, and the states are already